A third and final example of a very tough case is what happens when you're a passenger in your friend's car and a deer jumps out in front of you on the highway or on the thruway. Is that a case? Well, again, the answer is it depends. What was the speed limit? What were the lighting conditions? Did the driver notice the herd of deer at any time before the deer jumped out? Was there signage? Were there other vehicles slowing down to make the effort to avoid striking an animal? The last couple of situations or scenarios, the kid darting out between two parked cars and the deer jumping out in front of an oncoming vehicle, those are generally qualified as emergency situations that could also move the needle as to how the driver's liability will be examined and scrutinized by a judge or a jury. But the gist of the emergency situation and the emergency doctrine, which follows as a matter of law in those cases, is pretty much as follows. The driver's circumstances or the way the driver was operating his or her vehicle at the time of the accident will be examined within the context of the emergency situation that it was. Is that different from someone who's just cruising along a city street, mind, being careful, being mindful, seeing what there is to be seen and going the speed limit? Yeah, absolutely. Obviously, a driver who's involved in an accident under what we'd consider more contemporary normal circumstances is going to be evaluated in a far different light than someone who has to jam on the brakes to avoid hitting a 4 or 5 point buck in the middle of the highway after going 65 miles an hour.